panel program this morning, or bordering on this afternoon, is a discussion about some of the more important subject areas that have to be addressed during the integration phase of an M&A deal, specifically real estate, employee benefits, and intellectual property. Our panelists on this presentation are Tim Arends, he's in our employee benefits group, Liz Buckingham, who is in our trademarks group, and Marcus Mollison, who is in our real estate group.
Good morning and welcome to our panel. As Jocelyn said, I'm Liz Buckingham. I have worked on a number of deals in the construction and engineering space, and I also counsel construction companies, engineering companies, and companies who manufacture products for those spaces on their intellectual property issues. So Robert Hensley earlier today, talked about the hard assets and the people being the most important things in the deals, and I don't necessarily disagree with that, but I am here to say sort of me too. There are some times where IP issues can be important, and I just want to raise your awareness about a few of them that tend to arise with increased frequency in your areas. I also, in your materials, have a handout covering the various types of intellectual property, which, mercifully for you, I will not go through now. So the first issue is when the seller's name is the company's name. So if you want to acquire a company, you want to acquire it for the hard assets and the people, but what does that really mean? I mean, you want to acquire the company for its reputation, for its goodwill, for how it's known in the industry, some of which is going to be based on the brand. And a lot of times, as with law firms, professional services firms, construction companies are named for their founders or multiple founders. And this raises special issues from a trademark perspective because under trademark law, surnames don't automatically receive the same type of protection that most other brands receive. You typically have to develop what's called acquired distinctiveness in your name. The market has come to recognize it. And that's, if you're buying a company that's been around for a while, that typically won't be an issue, but just something to keep in mind. So in terms of how to do your diligence, if you have a seller who isn't so sophisticated, the starting point may be, we don't have any IP, we don't have any trademarks, we don't have any registrations. Well, they're obviously using brand names, they're using websites, they're using domain names, so you need to just dig a little bit deeper to see what's there. And also, especially if you're buying a company and you're going to expand the brand geographically or maybe expand their brand into some complementary products or services, you might want to do some searching on your own to surface some liability issues, because the seller may be able to say to you quite accurately, there's no problem with your using the company name, and that may well be true, but if they're only in a 3-state area and you want to roll it out nationwide, obviously you want to do some more diligence. Also, if you've got, if they're individuals or, their signatures or their likenesses for the founders are used in the company materials, you might need to get rights of publicity from those individuals. Those may be personal rights not owned by the company. And in terms of drafting tips, if you've identified that the founder or that the head of the IT or, someone else owns trademarks, owns trademark registrations, owns domain name registrations, then you'll want to get those cleaned up either before signing or before closing. And just to follow up on the last panel talking about mitigating risk, ways that you can do that in this area are to have warranties that the company owns all their IP, that it doesn't infringe, and then you can get into the indemnification issues so that you've got some protection there. Maybe you'll have insurance, or maybe you'll have some sort of an escrow that you can tap into. Particularly if it's an asset purchase agreement, you want to make sure you schedule the list of unregistered trademarks, business names, assumed names. Folks always want to give a very short list of what their IP is, and if you press them, you can get a much, probably a much more complete list. Another issue on the name front relating to something that John and Robert talked about earlier, and that's the idea of wanting to get a non-compete. You may want to get a different kind of non-compete if it's their name. You may want to get a non-compete that just goes to they won't be using their name either directly in competition, or maybe it's foreseeable that they might use it in some sort of a complementary area as well, some sort of a service or support area for the business, and you might want to include that as well. So for implementation tips, transition planning, if you're combining names or if you're phasing it in, obviously something to have worked out with the sellers, employees who are joining you, and the buyers. If you're going to be expanding your lines of business or your geographic areas, you want to protect that, and you also want to have watch services to surface infringements. And let me just say that it can be a challenge to enforce rights when you have your name based on a surname, because other people can say to you, "What do you mean? I've been using this is my last name. You can't stop me from using my last name." And in fact, you can, but it can be shall we say, a more challenging conversation. And then in our online world, you want to make sure you're checking app stores if someone's trying to register a rogue mobile app. So the second issue I want to talk about is copyright ownership. And here, you work in industries where there's a lot of collaboration, you have a lot of subcontractors, you have a lot of business partners, and it may be that you haven't formalized your relationships with written agreements that indicate who owns what. And that can be a problem from a copyright perspective, because the copyright law says unless you have an employee who's working as part of their job to create something for you, you have to have a written agreement assigning rights or determining rights. And so obviously, as part of due diligence, you'll want to dig in and figure out what's important. What are the key, is there software that's important? Are there blueprints, websites, technical manuals, whatever might be important for your deal? You want to figure out, where it exists and who owns it. You might need to look at vendor contracts, and that's obviously something that we do, dig in and figure out what the lay of the land is, or we may need to talk to key employees to figure out who owns what. And so obviously if you surface a problem like this, there are things you can do to mitigate it. You can try and get an assignment from the joint owner. It may be a kind of assignment that's a quit claim. I'll give you everything that I have in it. You may want to adjust the purchase price if you decide I'm going to exclude these assets because they're not going to be able to convert them. And in the implementation, you want to make sure that the seller forms what the employee agreements are, what the vendor agreements are, really truly reflect the creation and then the subsequent who's going to own the copyrighted materials that you're creating. The third issue I want to talk about are trade secrets. And here, it can be difficult to identify them and define them, again, because of the collaborative nature and the informality of the agreements, of the working relationships in your industry. You only have a trade secret if it has competitive value and if reasonable secrecy measures have been applied and continue to be applied. So it's very important to dig in on diligence. I mean, they may say, oh, yes, we've got this, very, very secret process, and you may talk to others that work with the potential seller, vendors, key vendors, and they may say, oh, yeah, we've been using that for years. Yeah, they shared it. We don't have any non-disclosure obligations. So another area to dig in and be concerned. So when you're drafting, you want to make sure that you can figure out a way to get effective delivery of the information that comprises the trade secrets, because most companies don't have them all in one area properly documented to the extent that they're useful and easy to find. You want to make sure that you're stepping into the seller's position in terms of non-disclosure and employee confidentiality agreements, so there's a seamless transition that doesn't destroy the trade secrets. And then, and in the implementation, you want to make sure that key employees, well, it could be that the best implementation strategy is to make sure a small group of critical employees are coming with you because they really know the trade secrets, they practice them and the know-how, and the best way to make sure that there is that transition of knowledge is to have the people transition. And, you know, you want to then have those folks focus on documenting what is most easy to set down so that knowledge can be shared appropriately within the buyer, and to make sure that that whatever system the seller had for trade secrets and the buyer has for trade secrets are consistent, and so folks understand what regime to follow and don't inadvertently disclose. So I just want to conclude my part of this panel by encouraging everyone to start early in thinking what the issues are. I mean, it's like, you know, like Robert said with the term sheet, right? What are going to be the issues? What are the key assets that if you're a seller, you want to get, you know, prettied up to sell? If you're a buyer, you want to focus in on. And if IP assets are included in that, you know, you want to start early. And because we've talked about, here's some ownership issues that you could have, and some, do we have all the protection that we need? So you can, you know, it just gives you space to work around the issues to solve the problems up front without really critically impacting the deal. If you've got a good due diligence report, that really can help you if you're a buyer, set the stage for, you know, asking for those particular indemnifications based on specific circumstances, or to, you know, to say you've got to have these assignments transferred before closing. So, you know, hopefully all of the panels today will give you some good ideas on how to get going with your diligence and what to negotiate and how to smoothly implement. And now I'll turn it over to my colleague, Marcus, who will discuss real estate issues.
Thanks, Liz. So I'm Marcus Mollison. I'm a partner in the real estate group here. I also happen to do a lot of construction transactional work and have been outside general counsel for some construction companies, general contractors, and so I have some experience in these areas. And again, I've been charged with talking about the real estate components, the real estate elements of these kinds of transactions. And I suppose in some ways it's fitting that that this is towards the end of the morning, and it's relatively, you know, just a few minutes, because that's really what I want to talk about largely in my incredibly simple PowerPoint presentation, which consists of one slide and what appears to be a typo, but it isn't. I've got timing as my first of 4 bullet points and as the fourth of 4 bullet points, and it really, I think, blends in well with what Liz was saying about early. And so that is really a lot of what I want to talk about is the timing of when to consider the real estate issues. And as you might imagine, I would suggest that it shouldn't be at the end. Although unfortunately, it's all too frequent in my experience that it does get held off to the end. And you know, I think there are some understandable reasons for that. I think real estate in these types of transactions is likely not the focus, and people are focused on everything but the actual physical real estate that is involved in the transaction. I think it was probably a fair statement that real estate issues are unlikely to kill the deal unless there were some really severe situation. And I think people are also concerned at the outset, well, do we really want to spend the money on doing real estate due diligence right now until we know we have a you know, more solid deal? I guess there's a lot of responses that I could make to those, but I'll give some quick ones here. The first one, as far as it not being the focus, I understand that, and I think it's absolutely true. But having said that, the real estate, I guarantee you, is a critical component. In all likelihood, if you're contemplating a deal or a transaction like this, you might be looking to expand a footprint. You might be looking to move into a new geographic area. And it will be critically important that for operations and other reasons to know that you have an understanding of what their real estate situation is, be it fee ownership or a lease situation or anything else. As far as and I think, like I said, it's true, I think, that it's unlikely that a real estate issue is going to kill a deal. Could, but probably unlikely. But it has a lot of potential to mess up a deal. and to delay a deal and to end up in situations where, well, we just didn't have time to deal with this, and so we're going to deal with it post-closing, whatever it might be, and have it a long tail that you've got to deal with. And so at best, it could be a nuisance situation. And on the cost side of things, I understand the sentiment to say, we don't want to sink a bunch of money into diligence efforts until we're a little more sure. But guaranteed, if there are any issues, it's going to cost you more in the end, especially if you're dealing with post-closing items, than if you could deal with them up front. So that's my plea is for timing, and earlier is always better. I have, there's a handout, a simple two-page handout. I don't know how simple it is, but it is a two-page handout, dealing with some of the things, and I think I say this on the handout, but it's certainly not exhaustive or comprehensive. I think that there's no way I could possibly do that, but I did want to kind of categorize and classify the kinds of issues that I would be concerned with, and some of the things that you might find as you are going through data rooms and boxes and who knows what else in trying to find these things. In all likelihood, it's not going to be well organized. You're going to find them everywhere, and as we go through these very quickly, you can see there's just all kinds of areas that this touches, and it's just, in my experience, unlikely that you're going to find all these things in one discrete, well-organized, logical place. And for that reason, these issues can just pop up all over the place. But the way I kind of view this is there are at least two objectives in your due diligence effort. One is to review and analyze what the status is, what the current state of affairs is, and then two, strategically address whatever it is that you find. And that really is much more where with long lead times, why getting on top and getting in front of the real estate is so important. So I'll turn our attention to this list, and I promise not to go through all this, but in part this is just to kind of give you an idea of the breadth, and again, all of the different ways that real estate documentation and issues can pop up. And I won't, the first 6 categories I've listed, I guess I would sort of say are sort of know what you're buying. You're talking about, title documentation, particularly if it's an owned site, although a lease site might also have a title policy attached to it. And what are you going to do with the title? It may be that you want to get a new title policy. Depending on the type of transaction, title policies are not assignable. If you are actually going to be merging into that company, you might be covered by that title policy, but in all likelihood, that's not what's going to happen, and your title coverage could be cut off. So that's something you want to think about. Moving on to surveys, again, kind of know what you're buying, know if there are any issues out there. Hopefully there are surveys. Hopefully they're recent, and whenever the property was acquired, assuming it's again an ownership situation, someone did their diligence and you don't have issues there, but you absolutely want to look at that. And then topographical as-built surveys, whatever they have, those are not likely to cause huge concerns, but they are things that you want to know about if those things exist. I won't spend much time at all on environmental since that's already been covered, but obviously that's a huge issue, particularly in an ownership situation where you could have successor liability involved, and a significant risk could attach. Similar to surveys, physical inspections. I should say too about surveys, if you were to decide to get, or that there was a need or you wanted to get title coverage, you're probably going to want to get a new survey in order to get the kind of coverage from the title company without exceptions that you want. But getting back to the physical inspections, it's crucial to see what's been done and then decide if there are things you want to have done, whether it's the condition of the building, what they found in terms of soil conditions, who knows. But and again, those documents are likely to be scattered, anywhere throughout their records. Occupancy and governmental documentation, I won't spend a ton of time on, but you want to make sure that if you, for example, are in a conditional use permit situation, making sure that how it's going to continue to be used is going to be consistent with what that permit says, making sure that you don't have any transferability, assignability issues. Those things are crucial, and it's something that's easy to overlook, I think. But if in order to operate there, you're relying on a permit of some kind, you better make sure that this transaction is not going to invalidate that. Construction documentation, I think that, again, this kind of goes without saying, but what are you buying? What do you have in terms of blueprints, plans, and specifications? Those things will be helpful going forward with any alterations you're ever going to do. You'll want to have those blueprints and any other documentation that they have. Depending on how long ago the building was built, and again, whether you're talking about the base building or tenant improvements, what kind of warranties are still available to the successor entity? Can those be transferred? Are there steps that need to be taken to transfer those? I want to spend a little bit of time on point number 7, dealing with leases, and this could come up in a number of ways. The leases, you could be landlord or you could be tenant. It just depends on the situation. But particularly where there are sites with the company involved that are where they are a tenant, there are a lot of issues. There are issues in ownership, but a lot of issues on the lease side. Obviously, you want to get a handle on, what's the state of the lease. You want to make sure you're not in default. You want to make sure you know what the term looks like. Are there extension options? Have those extensions been properly documented? And then a huge issue is on assignability. Is this transaction going to trigger an assignment or a transfer that is not allowed under the terms of the lease? Do you need to get landlord consent? What are the conditions of that consent? All of those issues are going to be crucial in making sure that you can continue to operate at that site. Conversely, what if you don't want that site anymore? What if you want to get rid of it? You're going to want to get a handle on how do we get out of this thing? How much longer do we? How much more term is there? Are there ways that we can deal with that issue too? And then on from there. But again, not time to get into all of those issues, but just know that there's a whole bundle of issues involved with leases, and again, often long lead items. If you have to get a consent from a landlord, that is a difficult thing to get overnight and spring on a landlord. And so again, is that going to kill the deal? Well, probably not, but it could really create some problems and some post-closing items that you're otherwise just not going to want to deal with. Estoppels, if you need to get an estoppel certificate from a tenant if you're a landlord, or potentially from the landlord if you're a tenant, getting assurances as to, okay, what is the rent? What are the operating expenses? Can we get assurances from our landlord or from our tenant that there isn't a default, so we don't have on day one an immediate problem? And that can be tied in with assignability as well. So all of those issues are really good reasons why, in the lease context, you really want to get ahead of these issues. Similarly, loan and finance-related documents, which again could be in a lease situation, more likely in an ownership situation. You want to be really careful with loan documents. Buried deep in the loan documents where people quit reading before they get there are often going to be, again, anti-assignment, anti-transfer that could trigger all kinds of problems, including a default, and really want to get your hands around those issues. Other things in loan documents that you might not think about, depending on the structure of the transaction, could be all kinds of loan covenants, debt to ratio covenants, minimum net worth covenants. What happens with those? Hard to say what the issues are, but again, suffice to say, those are just illustrations of things that you really want to keep an eye on. And again, if you need to get a lender consent, you don't want to do it the week of closing, and can really create problems, create delays, and just avoid the headache and get on top of those things early. The last piece, other ancillary agreements. Again, these are just a couple of ideas, but if you have a property management agreement, it is very common in property management agreements to have termination rights be triggered in case of any kind of a transfer. So you want to understand what that is, and you're probably going to do some negotiating with that property manager and maybe amending those contracts before closing to make sure that that property manager is still going to be there after the transaction closes. And so again, covered a lot of things in a very short period of time. But it's all really by way of saying, oh, do everything you can to avoid either these critical issues or these nuisance issues, so they don't end up being post-closing workarounds, delay your closing, and frankly, increase your risk if you have to assume risks that you otherwise could have dealt with had you been in front of the problem. There you have it.
Okay. My name is Tim Arends. I'm chair of the Employee Benefits and Compensation Group at Dorsey. Our group has we have 12 lawyers in 3 different offices around the firm. And we work on a variety of, really almost any employee benefit or executive comp issue. But a large part of our practice is working on merger and acquisition transactions. And as part of that, we often get to see the construction or real estate type of deals. And there are some unique issues that hopefully we'll highlight here as we go through. Get to the right slide. One of the themes, of course, this morning has been asset versus stock. What liabilities do we assume? What do we not assume? And that also comes into play in the employee benefits world. There are a couple of bigger ticket items that we have to identify that can follow an asset purchase, which I think a lot of particularly smaller companies doing the acquisition often are surprised by. One of the things we want to continue to focus on is the type of the transaction and then what are the liabilities that could possibly attach. And as part of that, when we look at the post-close structure, that also drives some of the integration decisions. And some of those are, is it going to be a continuing business or is it a standalone business after the deal, a separate standalone business? How are we going to integrate into the larger buyer's operations? What's it going to look like from the seller's perspective? Do they have a paternalistic approach to their employees and want to make sure that they're all taken care of? And how do we handle that? And all that kind of rolls into kind of the end product of how do we get these people moved from company A to company B or integrated into our own benefit platforms. Big ticket items, though, in terms of liabilities that can flow even if it's an asset deal. We always are concerned about multi-employer pension withdrawal liability. From the benefits perspective in these deals, that's probably the biggest showstopper, if there is a benefit showstopper. Again, like a lot of areas, it's not, benefits isn't going to probably kill the deal, but this is one that you need to get your hands on right away at the very beginning because it can be huge. It really, we've seen situations where an acquiring employer has learned kind of close to the end where the withdrawal liability on a per employee basis has been upwards of $100,000 an employee. And that may be fine if the buyer plans to continue running the business and the operations and keep the same number of employees around into infinity. But if there's ever going to be a reduction in force or maybe they want to sell it to somebody else or a shutdown of some sort, that could create huge liabilities for them. The other kind of showstopper from a benefits perspective is single employer pension liability. You don't see this as much anymore, but because of the decline in defined benefit pension plans, but it's still out there, and it's important to know early what the liabilities are versus the assets of those pension plans so that we can plan for what's going to happen post-close from a financial perspective. Lastly, COBRA, continuing healthcare obligations. As most of us know, if we change jobs, we have a right under COBRA to continue health coverage. And we've had a number of employers be surprised from an asset acquisition perspective that they can somehow be liable for providing COBRA to people that don't even come over with the deal, that may be terminated prior to the deal or as a result of the deal, and they have a COBRA right. And the reason in an asset transaction they would have a COBRA right is the COBRA rules are built such that the government is very concerned that, at least when COBRA came out, that people had a right to continue coverage. And the regulations under COBRA make it very clear that the parties can bargain as to who has that liability. However, if there isn't any clear documentation as to who's going to retain that liability, somebody is going to keep it, and that somebody is going to be most likely the acquiring entity, because the seller is no longer going to have a plan. So those are kind of the big ticket items that could potentially get in the way of a deal, but more than likely not. Some of the key documents that we worry about in the benefits world, obviously the purchase agreement, and back on page, I think it was 81, there was a list of things that that we can do to deal with issues that we come up along in diligence, whether it's special indemnification, tightening up the reps and warranties, maybe an escrow, if there's some problem with a benefit plan, and those are techniques that are typically used. But from a purchase agreement standpoint, typically the buyer is going to want to have more reps, the seller is going to want to have fewer reps. And as Ryan kind of indicated before, there are reasons to be more specific in those representations, and the same applies to the benefits world. We've got some ancillary agreements that come into play, executive employment agreements, the promises that are made there. Oftentimes there are going to be severance, change of control, or other retention type of promises in those agreements that have a fairly long tail. There's also some tax compliance rules that are commonly tripped over under Code Section 409A that need to be dealt with on the front end. So the sooner you can look at those and identify what they are, the better off you're going to be. Again, disclosure schedules, from a seller perspective, we'd like to see more. The buyer would like a little wiggle room in their disclosures. But some of the things that we come across in the disclosure schedules are things like there's a compliance problem. We both know about it, both the buyer and the seller. They've talked about it maybe in some of the diligence. How do we deal with it on the disclosure schedule? And we want to be sometimes a little more nuanced here in the benefits world, because we don't want to leave a roadmap for the regulators to come back and knock on our door and give us a friendly audit of the benefit plans. So there's some thought that needs to go into that from time to time when we do identify problems. Some of the points of emphasis and diligence, we talked about COBRA, we talked about multiple employer withdrawal liability, and we talked about defined benefit pension plans and the funding status. The other thing that comes up quite often is the 401k plan. And I can tell you that there's not a 401k plan on the planet that doesn't have a problem of some sort, whether it's a participant loan issue, contributions being screwed up, distributions being paid when they shouldn't have. There isn't a plan out there that's completely compliant. That's okay. The benefits world recognizes that. There's a lot of tools in the toolkit to fix those, both from a regulatory perspective and just from a let's do the right thing perspective. But they can be significant. Generally not showstoppers, but we had an instance in one case where we had a plan that had 1,000 participants in it, and the contribution formula was screwed up and didn't comply, and it's going to result in a $30 million contribution because it went on for about 10 years. So those are the types of things that you want to avoid. Typically, you're not going to find big problems in the 401k plan, but you will find something. Non-qualified deferred comp plans, I think the takeaway here is, are they compliant with Section 409A? And if you see them and you see a reference to 409A in the agreement itself, you know that they've at least thought about it, which is a good sign. But they're going to be full of triggers of like change control payments and the like. Often, bonus payments and things like that. Stock or stock options or other types of phantom equity also come into play there as well. We talked about the unions. Primarily, it's going to be the multi-employer withdrawal liability that's going to be the key there. And the problem just on the multi-employer withdrawal liability is that oftentimes, the way these work from an accounting perspective is they're about a year in arrears, and every multi-employer plan that I've come across is extremely underfunded, and it's kind of the rat's leaving the sinking ship. Every employer wants to get off them as soon as possible. And so you're going to get probably in the diligence a report that's a year to 18 months old. And you can oftentimes have the fund, the Teamsters plan or whatever they are, update the reports for you so you can help determine what the liability is on a more current basis, but it's a difficult thing to get your arms around. So a lot of thought from an ongoing business perspective will need to go into how you want to handle that. On the closing side, compliance, there's going to be some plan cleanup typically if you're acquiring the plans. And you can acquire plans in an asset acquisition as well. For example, if the employer is going away, sometimes the buyer will enter into an assumption agreement where the plans will be assigned to the buyer and assumed by them, in which case, there's another example of an asset acquisition where you're going to take on liability that maybe you otherwise wouldn't have. The plan documents, you're going to want to make sure that those are in order, and that's generally going to take a legal review to do that. Oftentimes there are plans that aren't terminated properly that we run into. Transition of plans, one of the things that the purchase agreement oftentimes addresses is what's going to happen post-closing and what promises are we going to make. It's not uncommon for a seller to ask the buyer in the covenants to maintain substantially equivalent benefits for up to a year. And you're going to need to address how that's going to be dealt with. But health and welfare plans, what a lot of people are concerned about as an employee is, okay, the deal's getting done. Am I going to be able to keep my health benefits, my current physician? How's all that going to work? And the sooner we get to working with the buyer or the seller and the buyer together on working with the transition plan on that, the better off the employees are going to feel and the less anxiety you're going to create in your workforce. Qualified plans isn't quite the anxiety issue that the health and welfare plans are, but again, a lot of people's assets are tied up in these plans and they're concerned about what's going to happen afterwards. So a discussion early on needs to happen as to what alternatives there are given the structure of the deal on how to address those retirement plans. Same thing with executive agreements. A lot of times you're going to want the executive agreements put in place and signed up as part of the deal. And the sooner we can start getting that negotiated, the better. The problem there is a lot of times the executives will want to wait till the very end because that's when they have the leverage to drive a better bargain. And just the enrollment issues. From an integration perspective, one thing that I've got a serial acquire client that has a very good handle on what their benefit cost is as a percentage of pay. When they add up their Social Security, their Medicare, their 401k contribution, their health and welfare benefit programs that they provide to employees, they've got it broken out as a percentage of payroll. And what they like to do is analyze the target company's benefits in the same manner so they can tell, okay, when we acquire this company and we're required to keep roughly the same level of benefits for at least a year, what kind of business problem does that create for us from a profitability perspective, at least in the short term? So one thing you'd want to do there is get a good handle on what they've got so you can figure out what it's going to cost to deliver on it after the deal. Integration, timing, and startup benefits. Generally, it's not a problem to integrate during the middle of the year, but you do run into a few transitional issues like starting over deductibles and copays in the health plan. It gets to be a little crazy at the end of the year from a vendor perspective to try to do these things at the end, but it can be done. You just need to get ahead of it. Earlier, the better. Obviously, we're trying to avoid gaps in coverage and participation, and that's sometimes something that's addressed in the purchase agreement. And then obviously the union issues that come up as well. That's all I've got. We've got 5 minutes left, and I think Jocelyn may have some closing comments for us all.
Thanks, Liz, Marcus, and Tim. This concludes our program. A couple of housekeeping issues. If you are in need of CLE credit or it matters to you, there's the green sign-up sheets on the table. Make sure you put down your name and sign off so you can get the appropriate credit. From my perspective as a construction litigation attorney, what I will tell you from my own experience when firms are acquired, the legacy claims that continue in terms of the litigation, I have a rule of thumb that I've adopted from watching a client and handling a very large legacy claim. 1 year. You should have a plan for how to get rid of that case within 1 year. And that sounds like a lot of time, but if it's a large case in protracted litigation, you know, some of the paths that case goes down may not be within your control. But from a board standpoint, and I've learned this from my friendly CEO client that had to come on and take on this case, that from a CEO's standpoint, you don't own that case during the first year. If the case continues beyond that first year after the acquisition, you own the case as the CEO. So it's just something to think about in terms of you're excited about bringing on and acquiring a new business, but if there are legacy claims, there has to be a plan to get rid of them. And if it's a large legacy claim, the time limit should be 1 year. With that, we bring it to a close. Many of us are going to stick around. If you have any questions, discussion items, feel free to approach us. And otherwise, you have our contact information. Call us. Thank you.